Well, good morning, everybody. Thank you so much for joining us. I'm hoping that you aren't picking up my speech because I've got a bit of an echo on the line. I don't know if that's how other people are hearing it. But welcome to those who've joined and subscribed to today's webinar. My name is Gemma Todd. I work as the Head of HR Services and Projects for Kingswood Group. And I'm not sure if you can still hear me. Can you give me a thumbs up, Grace, if you can hear me?
Yeah, no, you're all good. We can't hear the echo.
You can't hear me?
The echo. No, I can hear you. I can't hear the echo.
Okay. Hopefully you can hear me now. There is an echo, though. Unfortunately, that's really distracting for me. So I'll do my best on this one, but it's not the best. So we're the reason why things are a little bit clunky is we're using a system called GoToWebinar. This is still a relatively new platform for us, and for those who haven't used it yet, everybody else is muted and I can't see you, but my colleague Grace is going to be in the driving seat today and moving the slides forward for me. It's important to stress today's webinar is a safe space where information and insights about what can be a difficult subject will be shared. So that's the spirit in which we are talking about this matter of sexual harassment in the workplace. We've got about 45 minutes together with time at the end for Q&A, and we will be moving at pace because there's a lot to get through. So please bear with, and hopefully that will be all right for everybody in terms of the timing. If you have any questions during the course of the workshop, do just pop those into the question panel, and Grace will be monitoring this for any incoming questions and will ensure they're raised with me at the end so that we can address all of those collectively if those subjects haven't been touched on during the course of the webinar. We will be sharing the recording on the website later, so for now, feel free to keep your cameras on and mics off to limit any background noise. So just a little bit about Kingswood Group itself. We are a HR specialist recruitment organisation. We deliver HR solutions tailored to organisations of all sizes and shapes, whether that's small, medium-sized businesses right the way through to larger organisations. Our services are designed to be flexible and comprehensive and support businesses in enhancing their operational efficiency, staying compliant with employment law and regulation, and ultimately freeing up organisations' time to focus on what matters to them most, which is growing their business. So whether you're looking at a new employee handbook or a contract, or right the way through to the more task-oriented matters of things like redundancy or TUPE, then we're on hand to help. We work on both a retained basis, but also on a pay-as-you-go or consultancy project-related basis as well. There is no one size fits all. We are a bespoke service, so we always tailor our solutions to meet the needs of the organisation. We also offer a very, very professional, highly respected recruitment service. So if you are looking to replace employees within your organisation in the HR, finance or professional services area, please do think of Kingswood Group and do get in touch. So just a little slide here about our recruitment protocol, and that's currently headed up by Amy. That's the next slide, please, Grace. Where she has where we've got proven success in placing quality candidates, and Amy would absolutely welcome a call with you if you're looking to hire a top-class candidate. So here we are for the subject of the day. So harassment, sexual harassment. So you may or may not be aware that on the 26th of October last year, new legislation came into being, which meant that employers had a legal duty to take reasonable steps to prevent sexual harassment and create safe working environments. So I'm going to break all of this down and give to everybody present today as clear a message as possible about what all that actually means and what the impact on the employer is, and importantly, what organisations need to do to meet that statutory duty. So let's have a look at the outline of what we're going to cover. What do I mean by the harassment and sexual harassment. So I'm going to try and give you as much information as possible to help you understand that statutory duty. The specific piece of legislation we're talking about today is the Worker Protection Act 2023. As I said, came into force October last year, which placed a proactive statutory duty on all employers to take those reasonable steps. But I want to stress the fact that regardless of this new piece of legislation, sexual harassment at work has always been unlawful. But before the 24 introduction of the new act, there was no legal obligation by employers when faced with a claim for sexual harassment at work to demonstrate that they had taken reasonable steps to prevent it from occurring in the first place. And that is what has changed in relation to this piece of legislation. That duty is now legislated on. So today we're going to cover what do we mean by harassment, sexual harassment. We're going to touch on the law relating to harassment, including employers' liability. And I'll be sharing some insights into the current protections for people in relation to harassment, sexual harassment, to help understand the new legislative change. And we're also going to touch briefly on third-party sexual harassment, because that is or third-party harassment, because that is something that's going to be coming in and firmed up in an amendment to the Act. We're also going to touch on the preventative steps that employers are expected to take to deter harassment within the workplace. So there are 8 steps that are set down by the Equality and Human Rights Commission, the EHRC, that set out by way of expectations for employers to demonstrate what proactive preventative measures they have taken to prevent sexual harassment at work. And it's important to stress that in relation to harassment and sexual harassment particularly, it's not a company matter on its own. It's a shared responsibility for every employee in the organisation to proactively safeguard against harassment within the workplace. And that applies to everybody, regardless of role, title, length of service, or seniority. So let's have a look about some statistics. And it's important to recognise that, you know, these matters have always been there. We perhaps don't hear about them so much, but they are now becoming much more in the public domain. And it's true that complex grievances involving allegations of sexual harassment are on the increase. ACAS reported in 2024 an increase of 6.2% on their 2023 records of recorded cases of sex discrimination, and 16% of those recorded cases of sexual discrimination involved sexual harassment. And sexual harassment queries received by ACAS more than doubled in 2024 compared to the year before. A huge 59% upswing in employee queries to ACAS relating to sexual harassment was also recorded, and a staggering 168% increase in employer queries about sexual harassment during Q3 of last year means it is definitely a subject on everybody's minds. In Kingswood Group, we've also observed a marked increase in activity with our clients in relation to both harassment and sexual harassment, including requests for anti-harassment and bullying policies, either developing new policies or updating existing ones, requests for training for managers on how to handle grievances correctly and sensitively, including how to conduct investigations into allegations involving sexual harassment, and requests for providing training to staff members on what harassment and sexual harassment is, and how they, as members of the client organisation, can play their part in the duty to prevent sexual harassment at work. We've also been working with clients to risk assess their businesses in relation to harassment and sexual harassment, supporting them to take the relevant preventative and corrective steps where needed. And we've developed a suite of documents and solutions to support clients with all aspects of becoming and staying compliant. Because we recognise the critical nature of this legislation, we have developed and uploaded to our website a free sexual harassment risk assessment to support employers with identification of areas of strength and areas for improvement within their business in relation to sexual harassment. So I do invite everybody attending the webinar today to go to the Kingswood Group website, www.kingswoodgroup.org, after today's webinar, and download that free resource. So, more statistics. Did you know that according to a 2023 poll from the Trades Union Congress, 3 in 5 women have experienced harassment of work, and a figure which increases to 2 in 3 for women aged between 25 to 34. Now, what do we conclude from that? Well, we could conclude that maybe younger age groups are more frequently at risk of harassment and sexual harassment, or are more willing to speak up about it. but it isn't. It is a snapshot. The fact is that within that group of people polled, there was a high degree of harassment at work, which relates to general harassment and also specifically sexual harassment. And it's not an isolated incident in most cases, with 57%, that's 3 in 5 women, saying they had experienced 3 or more separate incidences of bullying and harassment at work. The TUC research from 23 also showed that around 1 in 5 employees of all genders had been exposed to verbal abuse relating to their LGBTQ plus status. So it is an issue that is not just restricted to women or the LGBTQ plus community, but also an Equalities Commission report in 2020 reported that 7.2% of men reported having experienced some form of harassment at work, with nearly 3% of those reporting having been sexually harassed at work. Now, bear in mind, research suggests that men are far less likely to report incidences of sexual harassment at work, so we can surmise that the true figure for men being sexually harassed at work may be significantly higher. So why now? As I said earlier, the Equality Act 2010 has always had protections in place to protect against harassment and sexual harassment in the workplace. So what has driven the change in the law, and why specifically around sexual harassment? This amendment to the Equality Act came in the aftermath of the Me Too movement in 2017. That movement had a positive impact and created many societal shifts, such as an increased public awareness of sexual assault and incident at work, people feeling more empowered to speak up about their experiences, many more sexual violence perpetrators being brought to justice, and, importantly for today's webinar, enhanced protections for people within UK industries. But it was clear that the Me Too movement exposed the fact that despite there being existing laws in place within the Equality Act to offer protection, they simply were not robust enough and needed to go further. In October 24, through the amendment of the Equality Act, the Worker Protection Act 23 came into force and placed all UK employers under a mandatory duty to take those reasonable steps to prevent sexual harassment in the workplace. Now, I'm sure many of the people on this webinar today will be aware of what the 3 types of harassment are as set down in the Equality Act, but just for clarity, let me just cover those off. Harassment related to relevant, but not all, protected characteristics. I will say more about that shortly. Sexual harassment and less favourable treatment as a result of harassment. In all instances, harassment and sexual harassment are deemed as unlawful. So let's talk about a definition. To understand whether harassment has occurred, we need to all understand what the legal definition of that word is as prescribed in the Equality Act 2010. In section 26 of the Equalities Act, the definition of what constitutes harassment is clarified as follows. Harassment occurs when A engages in unwanted conduct related to a relevant protected characteristic against B, where the conduct of A has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. When deciding whether conduct of A should be considered as having the purpose of or effect of violating B's dignity or creating an environment, as described, the courts will take the following into consideration: the perception of B regarding the conduct of A, any other circumstances of the case, such as whether it was consensual between A and B at the time, or whether it was not, e.g., it was unwanted, and whether it would be considered reasonable for the conduct of A to have had the effect that it did have on B. Each case will be looked at on its own merits, of course, and it would be for the court ultimately to decide whether harassment had or had not taken place. And remember, the court places a very strong weighting on the impact of the actions or behaviour on B rather than on the intention of A. Almost to say that the intent is not in discussion and it's the impact that has primacy. So I mentioned the fact that and stressed the emphasis of the word relevant protected characteristic, as opposed to the more general term of protected characteristics. Now, I'm sure everybody on the call today will know about the 9 protected characteristics prescribed in the Equality Act 2010, namely those that are on the screen right now. sex, gender reassignment, race, religion belief or lack of, sexual orientation, disability, age, maternity, pregnancy, and marriage and civil partnership. So these are all set down in the Equalities Act, and they're all very familiar to most of the people on the call today, I'm sure. But when we're talking about harassment, it would be automatically considered discriminatory if the behaviour or conduct related to one of 7 of those prescribed protected characteristics, which are the first 7 on the list and exclude pregnancy and maternity, marriage and civil partnership. And that may come as a surprise to some people, because at first hearing, it may appear not to be considered harassment if someone was singled out for less favourable treatment or unwanted attention on the grounds of their pregnancy, maternity, or marriage and civil partnership. But be aware, less favourable treatment of someone because of their pregnancy, maternity, or on the grounds of their marriage or civil partnership may not be considered harassment, but may be likely and probably would be likely to be considered discriminatory on the grounds of sex or sexual orientation. It would still be deemed as unlawful. That's the important message to take. But where we are applying the word harassment, harassment is deemed to have occurred when an individual has been subjected to that unwanted conduct related to one or more of those 7 relevant protected characteristics, and that unwanted conduct has the purpose or effect of violating an employee's dignity or creating that intimidating, hostile, degrading, humiliating, or offensive environment for that employee. So let's unpack the words unwanted conduct a little more, because that covers a broad range of actions and behaviours. Harassment specifically uses the word unwanted conduct when it's in its definition. And you can replace the word unwanted with the words perhaps unwelcome or uninvited. In all cases, unwanted means unwanted by the recipient of that conduct. So they don't want it, they haven't invited it, it's not reciprocal, and it's not consensual. When deciding whether it accepts that, subjectively, the reported conduct, whether it accepts that, whether the reported conduct was unwanted, a tribunal or court will consider the recipient of the conduct's subjective point of view as prima facie. However, albeit that it's not necessarily required for the recipient to have said at the time that they have been subjected to that conduct that they objected to it for it to be determined as unwanted, when deciding whether a claim has established whether the conduct was in fact unwanted, a tribunal or court may consider whether or not the recipient objected either at the time or subsequent to it. This is why people should speak up at the time or shortly after when they feel they have been subjected to unwanted conduct. If it is on record and it is documented, then it is irrefutable. Not only does that provide opportunity for potentially early informal resolution, but it can also ensure that an individual's objection to the unwanted conduct is recorded and addressing the matter can be tracked and monitored by the employee. An example of not speaking up at the time and how that can impact is something I'm just going to touch on next in this first case study. So there's a lot of words on the screen here, and these slides will be available to everybody to view after today's webinar. But let me just touch on the main points of this. So in the case of Papashvili versus the governing body of a school and others in 2021, Mr. Papashvili, who was a teaching assistant at a school in West London, accused his head teacher, Ms. O'Shea, of sexual harassment after she made inappropriate comments about his fit body and his Speedos. In 2020, he made a complaint of sexual harassment against O'Shea, in which he referred to unspecified incidents at staff meetings where she had repeatedly referred to his fit body, as well as an incident in June 2020 where she told him she wanted him to take her to meet his parents. She wanted him to take her to meet his parents. Now, witness stated that these comments were treated as banter amongst colleagues. And after a period of absence, the claimant was dismissed for gross misconduct. And in 2022, a tribunal found that he had been unfairly dismissed and was subject to 7 incidences of sexual harassment between 2017 and 2019. The remedy hearing awarded him 9.3 thousand in compensation, which was significantly reduced because the tribunal ultimately found that he had lied to the tribunal, etc., etc. Now, what does this case tell us? Well, obviously, speaking up, that all complaints of sexual harassment at work should be taken seriously, whether they be against senior or junior personnel. That sexual harassment is never acceptable, even if it is considered banter or a joke. And whilst it was unusual that it was brought by a male rather than a female, sexual harassment clearly applies to individuals of any gender. And we may acknowledge that sexual harassment does tend to feature complaints by women rather than men, because women perhaps potentially are more likely to speak up from time to time. But this shouldn't be taken as a defence that and to be relied upon at any point. Excuse me. Sorry, just got to the perils of working from home. So let's talk about the unlawful act of sexual harassment. And let's take a deeper look at this. So as you recall from the EA 2010, sexual harassment is one of the 3 specific forms of harassment. And sexual harassment itself is deemed to have occurred where person A is subjected to unwanted conduct or behaviour which is of a sexual nature. And it's important, we're going to unpack those words in a moment. Or where person is treated less favourably by another because they've either rejected or submitted to unwanted conduct or behaviour of a sexual nature. For example, an employee being bypassed for a promotion because they did not submit to the sexual advantage of a senior personnel, or conversely, because they did. It's important to understand that the conduct or behaviour does not need to be sexually motivated. And that's an important distinction between sexual in nature and sexual motivation. And it can be performed by somebody of the same or of a different sex. For example, if a male worker were to alter an explicit pornographic image by photoshopping an image of his male colleague's face onto it and then circulating that round, say, a private WhatsApp group in the workplace, leading to others to ridicule the subject and making derogatory comments about him, whilst we could argue there was no sexual motivation behind the Originators Act, the use of his colleague's face on a sexualized pornographic image is sexual in nature, and that could constitute unlawful sexual harassment. We talk about the words unwanted conduct, and it's quite helpful, I think, to just understand what that might show up like. So some of these are very obvious and they probably warrant very little clarification, but let's take a closer look. So sexual comments or jokes, commenting on a person's body, male or female, or body parts in a sexual way, even in jest, could be construed as both sexual harassment and sex-based harassment against the protected characteristics of sex if the comments were more relatable to one sex or another. Displaying sexually graphic pictures, posters, or photographs, and that includes sharing images or other materials, even in private or on community groups like WhatsApp. Obviously, suggestive looks, staring and leering, propositions and sexual advances, asking somebody to engage in a sexual act, for example, even kissing, could be considered sexual harassment if that was unwanted conduct. Making promises in return for favours, sexual gestures, and this includes facial expressions, hand gestures, body movements that have a sexual reference in nature or common understanding. I won't demonstrate any of those, but I'm sure most of the people present will know what those could be. Intrusive questions about a person's personal life or sex life, or alternatively discussing one's own sex life, oversharing. This could not only be asking intrusive by asking people for information, but by providing information that actually is unwanted by the recipient. Obviously, sexual posts or content on social media, spreading rumours about an individual, and sending explicit text message or emails. In Bratt versus GQC solicitors, Bratt was employed as a legal secretary for a firm of solicitors, and her boss sent her a WhatsApp message which read, "Hi, sweetheart, see you in the morning," with 2 kisses. He said, in his defence, it was intended for his girlfriend, and that when he realised that he had sent it inadvertently to Bratt, he immediately deleted it, then sent Miss Bratt another message which said, "Oh, that was a bit naughty for a lady." Initially, Bratt accepted his explanation. However, the following day, he told her that he had intended to send a message to his daughter and not to his girlfriend, which is what he'd previously said. And then later conversation that he was actually single, implying that he didn't have a girlfriend at all. Miss Bratt believed the message had been intended for her, found it unwelcome, and brought a claim for sexual harassment. And the tribunal accepted that whilst the initial message may have potentially been inadvertently sent, it was reasonable for her to have concluded that her employer was lying because of the inconsistencies in his explanation. And that, along with other instances of sexual harassment at work, had the effect of creating an offensive environment for her. And obviously then the unwelcome touching, hugging, massaging or kissing. This is the one that most people think about when they are considering what may or may not be sexual harassment. And don't forget, when you're considering this, it has to be sexual in nature. So a question that was asked of me just a couple of days ago was, if you put your hand on somebody's arm to move them out of the way, could that be considered sexual harassment if it's a male to female or female to male dynamic? And I said you would have to go back to that initial descriptor of unwanted conduct that is sexual in nature. If it is not sexual in nature, then it may not stand as a sexual harassment case. However, touching, hugging, massaging, kissing, physical contact is the most frequently cited type of sexual harassment, and it is not exclusively male to female. Remember, nearly 3% of men in the Equalities Commission study in 2020 reported sexual harassment had been against men, and that could have been female to male or indeed male to male. So we do need to stress that the sexual interaction that is invited, mutual or consensual, would not be considered sexual harassment because it's not unwanted. But you should all be alert to incidences where sexual conduct that has been welcomed in the past can become unwanted. For example, an employee who is in a brief and consensual sexual relationship with her manager or his manager, where they tell the manager that they have changed their mind and they don't want that relationship to continue, and the manager persists in trying to get that employee to re-engage in the relationship by trying to kiss them or touch them or making comments to them, such as stop playing hard to get or inviting them to come and see them after hours. It's important to recognise that although the original sexual relationship was consensual, the manager's conduct after the relationship ended would be unwanted and it would be sexual in nature and therefore could well be proven to be a sexual harassment case. Let's move to the subject of banter and the links to sexual harassment. So banter is described as an exchange of light, playful, teasing remarks. And that, on the surface of it, doesn't sound too bad, does it? And in many organisations, banter seems to feature as part of the way that people engage with each other and the culture of the organisation. And banter in itself is not an issue, providing it doesn't come at the expense of somebody else's protected characteristics, relevant protected characteristics, or indeed sexual harassment. So why do we consider, what do we do when we consider matters of banter? So for example, nicknames or expressions around, and jokes. Well, that light, playful, teasing remark can very quickly become unlawful. And if you recall the wording of unwanted, also uninvited, unwelcome, which has the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment, you can see very quickly how banter can tip into that space. Some may think that banter is just a bit of fun, part of a jokey, relaxed environment, but comments can also be considered bullying or even harassment if someone is subjected to discriminatory name calling or jokes. And this can be a hot territory when it comes to banter relating to age, gender, sexual identity, race, nationality, amongst others. There's often a very fine line between what's considered harmless banter and what may amount to unlawful discrimination or harassment. Context is everything. It is the interpretation, remember, the impact of the banter on the recipient rather than the intention of the speaker that has primacy. For example, a couple of claims from the past. A woman whose boss humiliated her in front of colleagues and customers by calling her a dinosaur because she was going through the menopause was awarded £20,000 in damages for, amongst other things, disability and sex discrimination. And a female employee in her 30s who won her claim of sexual harassment after her boss referred to her as a good girl, even after she had objected to it, then had harassed her to change her profile images on social media, telling her that he believed that she looked fat. So when it comes to the use of nicknames or comments, this can quickly lead to a much bigger issue if the recipient of that perceives the bantering as offensive or discriminatory. Now, some people may not object to a nickname given to them. They may find it funny and being used without malice aforethought, but equally they may not. An example of that is in an industrial space where a 69-year-old plumber was referred to as Half Dead Dave by his colleagues. He found that offensive, he found that discriminatory, and he took his employer to court and he won £25,000 in damages for, amongst other things, age discrimination. So banter in itself can be that light exchange of playful teasing remarks, but it can very quickly spiral out into something much more deep, much more offensive and discriminatory. So it's worth considering that if someone is using a term or an expression or a nickname, if the question is in the mind as to whether it is or isn't discriminatory or offensive, then it's probably a fair indicator that it shouldn't be used. A case study around that that's a case study that's already been covered off. So this is where the unwanted conduct was referred to. So let's move on to the reasonable steps. So we've talked a little bit about what harassment and sexual harassment is, talked a little bit about some of the case law around that, and also talked about what defines the terms harassment and indeed sexual harassment, the unwanted conduct that is sexual in nature, or less favourable treatment in terms of sexual harassment. So what can businesses do? So knowing what doesn't run the risk, the reasonable steps can often leave people scratching their heads as to what does reasonable actually mean. So the reasonable steps will very much depend on an organisation. For example, the size, scale, demography, budgets available, etc. But what we do know is that the law regarding sexual harassment will see any sexual harassment claim won by the employee, where an employee is deemed to have failed to take reasonable steps, will likely have any award payable increased by a further 25%. And remember, for discrimination claims, which covers harassment in all forms, including sexual harassment, there is no upper limit on those awards. So it means that if an employee wins a claim for harassment, sexual harassment and discrimination, the amount awarded could be significantly higher. So what can employers do? Those reasonable steps are set down in the Equalities and Human Rights Commission's recommended 8 steps that employers are suggested could be reasonably considered to be taken. So let's take a look at those in a bit more detail. First of all, implement a policy. The very basic requirement of having a policy that is extensive, clear, and covers every aspect from reporting to management to third-party harassment, and extends to all employees regardless of location, employment type, or length of service. The policy needs to be accessible to all and reviewed regularly and revised as often as is required, particularly after any claim has been made. Engaging the workforce. Your workforces are a valuable source of insight and information. So has anybody actually surveyed to find out whether there are particular areas of problem or whether there are issues within the workplace already that have just not been addressed? And that kind of information can really feed into a prevention strategy that has merit. So holding regular one-to-ones can be helpful, but also implementing a regular employee survey around this specific subject of sexual harassment. That can establish what works well and what could work better, as well as identifying hotspot areas or locations in a business to support more targeted intervention. Surveying staff anonymously on their experience of sexual harassment, perhaps even at exit interviews, including whether they have witnessed or been subjected to harassment, and whether they have or would in the future report it, and what barriers might exist to that, would also be valuable information to gather. That would also support the development of a really solid prevention strategy. Fortunately, within Kingswood Group, we're lucky to work with a really excellent employee engagement provider who does build comprehensive, credible, professional, reliable employee surveys, and we would be happy to connect anyone with them as part of the development of their prevention strategy. Step 3 is around conducting risk assessment. Now, I've also signposted you to a risk assessment on our website, but as a more extensive process, having gone through the first round, perhaps using the Kingswood model, is to go into a more detailed risk assessment to take steps to identify and then to reduce, remove the risk that may be flagged. Mapping out that risk assessment where such risks of the likelihood of sexual harassment might occur will certainly aid in the development of the reasonable steps and would be a significant part of your defence if a claim were later to be raised in the courts. So, for example, you might want to risk assess areas such as where there are power imbalances, or where staff may be working alone or at night, or where diversity, or indeed lack of it, could be a consideration as a risk factor. It could also be where employees have more client or customer facing duties, and that is something related to the third party element of the legislation, which is going to be firmed up as part of the Employment Rights Bill changes that are coming in over the course of the remainder of this year and certainly into next. It goes without saying, areas where risks may increase, such as alcohol, where parties, events involving alcohol may be involved. This can all increase risk. And remember, what you measure, you can manage. If you have the opportunity to gather information about those sorts of evidences, then you can use that as part of your prevention strategy when you're building it. The fourth step is reporting. Reporting is absolutely critical. Employers need to know what's happening at the time, and this is obviously really important, because if you don't know what's going on, what can you do? So employers should be considering using some sort of reporting system or tool, such as an online or independent telephone-based service where employees can safely and securely report their concerns if they don't feel that they're able to do that within the workplace. They should be able to do that either named or indeed anonymously. Keeping centralised confidential records of every concern raised, whether that's formal or informal, is also important, as it enables trends to be identified and makes targeted interventions far more impactful. Some of you may have EAPs, which may offer you a supported whistleblowing service. Some of you may have an internal whistleblowing facility. These are things that you can tap into in relation to that being able to report either named or anonymously. Training, of course, step 5, every business should be considering training for their employees, and not just as a one-off activity, but on a regular refresh basis. And the training should cover what sexual harassment in the workplace looks like, what to do if people experience it or witness it, and how to handle complaints and concerns, signposting people to where they can get support. In industries where third-party harassment from customers may be more likely, employees should also be trained on how to address these issues. And all training should be, as I said, regularly reviewed for its effectiveness, and refresher sessions offered at regular intervals. Again, at Kingswood, we've developed a range of solutions for businesses of all sizes and budgets around the training in the subject of harassment and sexual harassment. So do feel free to reach out to us if you'd like to know a little bit more about that. Step 6 is having clear procedures for managing complaints. Now, I'm sure there isn't a business on this call today that doesn't have some form of grievance management system or complaint management system for its employees, and it's important that that is clear, accessible, understood by everybody, and that when a complaint comes through, it's acted on immediately with the purpose of resolving the complaint, and also taking into consideration how the person on the receiving end, the employee who's raised the complaint, might want it to be resolved, and making sure that confidentiality of all parties is respected. The complainant should be protected from any ongoing harassment or from being victimised during the course of an investigation or a complaint. And that might involve businesses having to take interventions such as moving the alleged harasser to another team or site, or indeed suspending them if it is not possible to move them elsewhere. If someone has made a complaint of harassment, that may also tip into a criminal offence, depending on the nature of that type of harassment. So you should speak to the individual about what they want, whether they want to report the matter to the police, and support them if they do wish to go ahead with that. And always keep those communication channels open so that the person who has raised the complaint is kept informed of the outcome, and outline any appeals process in a timely manner. Step 7 is the third-party harassment management piece, and employers should be taking steps to prevent this type of harassment, including putting reporting mechanisms in place or assessing high-risk workplaces where staff may be left alone with customers and therefore more vulnerable to harassment or sexual harassment. And as I said, the changes with ERB are going to firm up this area of the law as we go forward. Step 8, monitor and evaluate. As I've said before, what you measure, you manage, and you can evaluate the effectiveness of your steps taken by looking backwards, reviewing the formal and informal complaints data to see if there are trends or particular issues or hotspot areas, comparing reported complaints with survey feedback to ensure that you're getting an accurate reflection of what's going on within your workplace and that you're able to take appropriate actions as a result. And also holding lessons learned sessions after any complaints of sexual harassment have been resolved, so that you can put in what you learn into practice as a result. And that may change policy and it may change process. We advise all organisations to conduct at the very least an audit or a checklist of what they already have in place in relation to these 8 steps to identify any gaps so that they can create a plan to address those gaps. The action itself of going through that checklist or audit would add to the body of evidence for a tribunal's consideration should a claim be made for discrimination, harassment, but especially sexual harassment. So I've mentioned a couple of times the future changes and to the statutory duty. So it's not the end. The launch in October 24 is just the first part, and coming at us, as I said before, through the Employment Rights Bill, likely to be implemented in its totality by autumn next year, contain a number of changes. One in relation to the wording, which currently says reasonable steps must be taken, and that is going to become all reasonable steps. And what does that inclusion of the word all mean? Well, the ERB has not yet defined what it means by all reasonable steps, but we can work on a fair assumption that all reasonable steps would include, at the very least, conducting risk assessments and formulating action plans from the outcomes of that to mitigate risk, publishing relevant policies and procedures and ensuring full and free access, and that those documents are regularly reviewed and updated in accordance with legislation, best practice or incident. Introducing steps to assist with the reporting of sexual harassment, including anonymised and confidential reporting mechanisms, as mentioned before, such as whistleblowing hotlines or EAP lines, and introducing steps to assist in the handling of complaints, such as a tracking and monitoring system to ensure that every complaint is managed to a conclusion, trends are identified and acted upon, and areas for improvement are addressed. When it comes to the courts, they are likely to consider the all reasonable steps defence currently applied to vicarious liability for discrimination and case law. So that would include asking, for example, what steps did the employer take, and were there other reasonable steps that the employer could have taken in relation to the preventative duty. In a case from 2020, the EAT, the Employment Appeals Tribunal, held that an employment tribunal should consider the following when deciding what is reasonable. And reasonable is one of those words in our circles which can sometimes be open to interpretation, but not in the case of the EAT. So in that instance, they said what is reasonable is as follows. The likelihood that had all reasonable steps been taken, would they have been effective in preventing the discrimination or harassment? What would the cost have been to the employer to take all reasonable steps? and was cost a reasonable or legitimate reason for not having done so? And what were the practical considerations when the employer did or did not take all reasonable steps that might be available? So it would be very much looked at through that lens, and that's the feeling that we have at the moment. But obviously, until the ERB publishes the outcome of its current consultation, we're not sure. But that defence, which is currently applied to vicarious liability for discrimination, would likely apply. As with all case management, everything needs to be looked at on its own merits, but we can draw from that prior application of all reasonable steps. It's going to be extensive and it's not going to be minor in its makeup. So what can you do? Well, there's a short list of do's and don'ts up on the screen right now. First, do take prompt action when a complaint is made. Do consider your working arrangements and keep up to date with all the legislation and best practice changes to make sure that everybody at work in the workplace is kept safe, and that's everybody, including your extended population. Highlight any organisational support and signpost people to provisions such as employee assistance programs. Do take complaints seriously and do investigate everything carefully and thoroughly, and approach every investigatory interview with a fully open mind without any predetermination. Do track and monitor progress of every stage of a complaint to its conclusion, and do seek professional support and help when required. Don'ts is obviously just as equally as long a list, but don't assume that one party or another is lying or exaggerating. Don't jump to premature conclusions. Don't try and avoid emotion. Don't try and keep the lid on things. Keep personal, don't bring your personal views into that interview process. Don't try and rush through the investigatory stage, because people who have been subjected to harassment, and specifically sexual harassment, may take a little time to be able to feel confident and capable of opening up. And don't forget to follow up afterwards to ensure that the matter has been properly resolved and that any lessons learned have been put into place. At that point, I'm just going to pause before I go further, as I've covered my main slides. And before I go on to the next set, I just wondered, Grace, have there been any questions arising that you feel that I need to answer from that part of the presentation?
There hasn't been anything come through as of yet in the box, but I'll keep an eye out.
Okay.
Chat when there is.
All right. That's great. Thank you very much. Do feel free to put forward any questions if you have them. More than happy to take any questions at the end. So I'm just going to touch on some other aspects before we move to the conclusion of today's webinar, and to give time for questions at the end. Some forthcoming webinars that we have within the Kingswood portfolio. We've got one coming up on the 19th of June. Same time slot, that's 11 till 12. That's flexible working from day one. This is to talk about the new changes to the flexible working law under the Employment Relations Flexible Working Act 23. Obviously, based on the fact that we know that the changes that came through that are already in place and that are likely to come through under any changes through the ERB are going to have impact. So we'll talk about a step-by-step guidance on how to manage requests fairly and lawfully based on the latest ACAS Code of Practice. We're going to talk about best practice approaches being used by other businesses to balance flexibility with operational needs, which is always a challenge. And we're going to cover some case studies from businesses that have embraced flexible working from day one.
Sorry, Gemma, I'm just going to jump in there. Just had a question come through, just asking,
Sure.
if an employee requests that a conversation is kept private and confidential and does not want to raise a complaint, are we still under duty to report it?
Well, the complaint is owned by the individual. So as with all grievances, they are owned by the individual. So if we took sexual harassment or harassment out of the equation and it was a complaint about pay or working conditions, and the individual said, no, I don't want to raise this, we would still have a duty to look at that, even if we weren't managing it through a formal process. With sexual harassment, obviously, that is a very sensitive area. And it may well be that we have to advocate for that employee and put some protections around that to say, look, the nature of the harassment is so serious that we do have to take some action, because we can't unknow what we know. So it is a bit of a balancing act, because if you bring a complaint forward and say, look, I believe I've been sexually harassed and it takes this form, but I don't want anything to happen as a result, then you're not complying with your duty of care as an employer to look after that person's welfare. But that sexual harassment could continue, or it could spread to other people. So there isn't a pat answer that I can give at this particular stage. It's more look at each case on its own merits, understand what it is that's preventing that employee from being unwilling to speak up and progress the case formally, and are there any other routes that you could go through to address the matter more generally in the workplace, such as using your disciplinary sanctions, etc., rather than going through the grievance route.
Thank you for that, Gemma.
Does that answer the question in a way? As I said, I suppose the answer to that really is there isn't a single answer. There are nuances within each complaint that has to be looked at. And sometimes people will say, I don't want to go down a formal route. What I'd like to do is go down an informal route and maybe have a facilitated conversation, or indeed a mediation, which would perhaps achieve a point of resolution in that particular area, without having to go down a formal grievance. Okay. Happy for me to move on, Grace?
Yep, there's no other ones in there.
Oh, okay, fabulous. All right, thank you. So I'm just going to touch on some of the things that I did reference earlier in the webinar today, and some of the useful tools that we have available free of charge on our website. Obviously, the one that I've referred to, which is the sexual harassment risk assessment, you can access that through the Kingswood Group resources section on our website. We also have the Employment Rights Bill checklist, and that's designed specifically for SME business owners to help navigate the new requirements, but it's a useful thing to look at regardless. And we keep that up to date as and when we are made aware of any kind of changes or conclusions from the consultation process for ERB and its amendments. We also have an HR benchmarking assessment, which is a really useful tool, because it helps you as a business, or business owners or business operators, to assess key areas of HR function and uncover actionable insights. So that would help with enhancing areas around compliance, efficiency, and employee engagement. And the good thing about all of these, they're free and they only take about 5 minutes to complete. And you will have a report delivered to your inbox as a result. So we are now at 11:55, and before now I'm going to stop talking completely, and I'm going to just sit back and say, if Grace, if you would just like to open the mics, if anybody has a question that they would like to raise.
So I don't think we can open the mics, but I'll keep an eye on the questions box if anything comes through.
See, I'm still learning this GoToWebinar platform. I need to go off and do a tutorial. If nothing else, to learn how to switch off the sound of my own voice in my ear when I'm speaking. Okay. I'm assuming there's no questions, Grace, because I can't actually see the chat.
Nothing else has come through, no.
Okay. All right. Fantastic. Well, it just leaves me then to say, within the time allocation, thank you all so much for being part of today's event. If you have felt it useful, if you feel it has given you some clarity about what you as an organisation can do to stop the harassment before it starts, and take those practical steps as set down by the EHRC, or indeed to give you more clarity around what constitutes harassment and sexual harassment in the workplace, then I have achieved my goal today, so I'm happy with that. But if you would like further support, if you want to talk about it more on a one-to-one confidential, no commitment basis, please do just reach out to myself or Grace or anybody at Kingswood Group. we'd be more than happy to have that confidential free chat with you about it, so that we can help you become as compliant as you possibly can be, suitable for your business. And I hope to see you on a future webinar. Thanks very much. Bye for now.